Alex here with part 159 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0. If you haven't seen it yet, that's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of this series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We left off in part 158 towards the middle end-ish with my execution. That was my first attempt at seizing my ex's assets for not paying the $50 a month on the judgments. And now we go into my motion for supplementary proceedings, which is another motion seeking to subject her to a debtor's examination. I think I have done this only once so far in the series. I believe the second time was on some kind of post-judgment discovery. So this is my attempt to do it again. And I didn't really have much of a mindset at the time. I remember, at this point I had primary physical custody and I'd won those 5 motions and pretty much wind in my sails. I imagined that I was optimistic about it because my ex was ordered to pay the $50 a month and she didn't. And I think we can actually get straight into this video and take a look at what I have filed. Here we have my motion for supplementary proceeding in the aid of execution. I am appearing before the court through and by my attorney and filing this motion for supplementary proceeding. This is going to be a pretty short motion, I imagine. These aren't really very detailed documents. Are not, I should say lengthy. There are quite a few details in it. So we have my factual background as per usual. The first paragraph is a sort of a summary paragraph which explains that we share a common minor child of age 8, that I am the father, my ex is the mother, that I have primary physical custody, and my ex has visitation rights. Next assertion is that on November 4th, we convened before the court on a motion to reduce medical and child support arrearages to a judgment, and that both of those judgments were entered. Next assertion is we're going into the argument section now. It's been over a month since November 4th hearing, and my ex has failed to pay her $50 payment on the judgments as ordered. Pursuant to the law, I'm entitled to examine my ex as a judgment debtor before a judge or domestic master. We previously convened before Discovery Commissioner Wes A's on August 16th for a debtor's examination, and I effectively used the information obtained to execute a bank levy and wage garnishment to satisfaction, and I am giving the court 3 filings. The first is a writ of execution, the second is another one of those, and then the third is a satisfaction of judgment, indicating both that I executed on my ex's assets, seized them, and satisfied her obligation. Next assertion is that my ex has also failed to pay towards child support. However, the proper forms have been submitted to the district attorney's office and will eventually be addressed by wage assignment through the district attorney's enforcement division. Conclusion. I am hereby requesting that the court command my ex to appear before the Discovery Commissioner to be examined as a judgment debtor. Next assertion, or actually I think that's it. Yep, we go into the affirmation pursuant to the law, indicating this document does not contain a social security number. And we go into Rule 5, Certificate of Service. This is, I don't think there is, oh, okay, I see why. It looks different because my attorney did it, and I don't know why. It just kind of threw me off a little bit there. But it is a Rule 5 Certificate of Service, pretty standard, indicating this document was mailed to my ex. That's it. Next document is a Notice of Entry of Order. This is indicating that the judgment... No, this is everything. This is not just the judgment. This is the whole order. Okay, yeah. This is the order that we previously went over in the previous video that we are filing a notice of entry of order on. It indicates, actually, it's not just indicating it's not just a notice. I always go through this. I have a video dedicated to this topic, guys. Take a look at the video notice of entry of order because it also triggers the timelines on filing an appeal. So the date that my ex has to file an appeal from does not trigger from the date of that order. It triggers from the date of this notice of entry of order, and that's because local rules say so. Next, we have certificate of service by Rule 5, indicating that this document was also mailed to my ex. And then the last document here is a notice of appearance. This is my ex's new attorney, Raymond Oster and James Barnes. I think it's only one of these that appears. The other person's just got his name. So it looks like it's Raymond Oster that signed it. I'm still not sure if he's the one that appears at other hearings and files things. We do have at least one hearing with this gentleman, maybe two. Pretty sure it's just one. And whoever it is, it's one of these two guys. It's not, they don't both come to court. It's one of them. And I'm going to find out which one it is, and I'll continue to show that person's photo throughout the series. For now, I suppose, since this was signed by Raymond Oster, we'll go with Raymond Oster, and if that changes, we'll keep that up. Going into the aftermath, I filed 3 documents. They were all, I believe, free filings. Yes, they were. No, wait, I filed 2 documents. My ex filed 1 document. The 2 documents that I filed were definitely free filings, so I incurred $0 in costs. My ex's document was just a notice of appearance. That's a free filing. That's also $0 in costs. I had an attorney, but my attorney was helping me for free, so I incurred $0 in attorney fees. My ex's attorney would have probably charged her 15 minutes to open up that file and go ahead and submit the notice of appearance. So I'm going to say 15 minutes is reasonable, and at the rate of $250 an hour, that's going to come to $62.50 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post those down in the comments below, and I will see you guys next time.